right, and I think it gives y'all a little pop-up real quick to continue. All right, good evening, everybody. This is a Foodwell Alliance and Law Farm presentation. The Law Farm is a project of my law firm, which is the Law Office of Michelle Namer, LLC. I'm an attorney, and I specifically serve farmers and what I call farmtrepreneurs in Georgia. I provide legal resources to food system at large, but I love working with entrepreneurs and the farming and food realm. And folks who are getting their business started and growing it, that is my wheelhouse. And Foodwell Alliance has generously funded me doing this webinar series, along with providing some other resources to Georgia. Well, Foodwell Alliance allows me to provide the resources to the Metro Atlanta farmers in the 5-county area, but their generous contribution also allows me to make some generous offers to Georgia farmers in general to strengthen your legal foundation in your business so that you can do what you've come to do, which is grow food and to feed people in our communities. So thank you to Foodwell Alliance for making this possible. Have something to take notes tonight. The first thing to write down is everything else on your mind. We will cover a lot tonight, so be present with me. And I say that every webinar, but I especially say that for tonight's webinar. As I was doing my run through of this material, it became apparent that this could be 3 or 4 different sections of a webinar. So there's going to be a lot of information coming at you tonight. I'm going to try and dial it back as much as possible and just give you what's pertinent, but we will cover a lot tonight. So come on into this space with me. It's your time to ask questions. I don't have a bullet point on here, but I notice a lot of folks have a tendency to not speak up with a lawyer right away for fear of not saying the right terms or for not using the right language. Please drop that fear at this webinar. Know that I am here to be of service to you. If you don't have the right language, if you're not sure what the issue is, that's what I'm here for. So don't be shy if something's on your mind. This is a great place to get it out and get some questions answered. Also, don't feel any pressure to keep your camera on. Make sure you're muted when you're not speaking. I will take questions at the end for sure. I will probably check in about questions as we go through. But if anything pops into your mind while I'm going through the material, you can type a question in the chat and I will try to keep up with those as I go. And then I will be sharing some resources that I like to use. And I invite you to follow along on your computer if you have it handy with the things that I'm showing you. If you want to try it on as I go, it's an opportunity for you to stop me if it doesn't work the same way on your computer or on your browser. And I'm happy to slow things down to make sure that you do get on the same page with those resources. And this webinar is part of a series. In June, we talked about agritourism and on-farm waivers. Tonight, we're talking about contracts and agreements. August 23rd, we will be talking about local government and zoning. And then in September, we're going to talk about everything farmtrepreneur and food business, IP, intellectual property, so trademarks, copyrights, and more. In October, we will talk about conservation tax benefits. So if you are a landowner or you plan to be a landowner, this is the October webinar is going to be really great for saving actual cash money. And November, we're going to talk about employees and volunteers. And then December, which I believe to be a slower time for farmers, we will just go from cradle to grave with business law and go over those important moving parts. And even if you have a lot of them already, if you have an operating agreement for your LLC, you already have your LLC established, you maybe even have employee handbooks or agreements. Even if you have those things in place, this is going to be a great webinar to be reminded of how you can strengthen those things, pick up some tips and tricks for making sure that the legal foundation of your business is as strong as you want it to be. So definitely keep an eye out. The August date is set. Keep an eye out for September, October, November, and December. I would love to have you here. And all of these are recorded, and you will be getting a follow-up email that has a link to the page on my website where the recordings are available to you. And I am a lawyer through and through, so of course I come with a disclaimer. This presentation will not provide legal advice to you. Legal advice is nuanced and it depends on your situation very highly. I will talk about that more tonight because with contracts, that's especially true. This presentation will provide you with legal information and education, and it will guide you to transform dense law into clear action steps. And then it will empower you to integrate those action steps, those legal tools, into your farm infrastructure. There is no attorney-client relationship created in this webinar, and there is no confidentiality preserved with what you share in this webinar. When you talk to me as a lawyer one-on-one, there's confidentiality in our conversation. I will not talk about what we've talked about to anybody else. When we have a discussion in a public forum like this, that confidentiality is not preserved in the same way. So when we do get to Q&A, and I'm going to ask a lot tonight for you guys to share any experiences that you've had, when we talk about those things, keep it as high level as you can. Don't get down into the nitty gritty, especially if there is any sort of conflict brewing or you think that there will be an issue in the future. Just keep those specific details out of it for tonight, and I will talk more at the very end about how we can work directly one-on-one to deal with those issues and get you that legal advice in the future. Okay, so before I hit record, I was talking about making a list of all the people you do business with, all the business relationships in your life. And I'm not sure, I can't see your list. That's the sad part about not being in person together. But I don't know if it's long or if it's short, but I'd imagine as you establish your business, that list gets longer and longer of the people you do business with. And who are you doing business with? And importantly, who affects your bottom line? When I wrote that bullet, I'm thinking about the person who owns the land you're leasing, or the people at market who are buying produce from you, or there are so many people that you do business with, but certain people affect the bottom line of your business. And those people, I don't want to say the people themselves matter more than others, but when it comes to those relationships, having clear contracts and agreements matter for your business success. And then I put the who in quotes because who's who is important. When you made your list of those people that you do business with, that you rent things from, that borrow things from you, all of those people, are they acting in the capacity of themselves as an individual, or are they another farm or business that needs to be treated as the entity and not so much the person? And do any of these relationships enter your mind when you go to sleep at night? And what are the thoughts that arise? And again, the land piece and leasing land or owning land, I would imagine falls into this category, especially those things that you really concerned about. I know I'm relying on this person. I know I did business with them, and I'm still thinking about what's going on. Written agreements can help you sleep at night. Written agreements are what can tackle those issues of what's on your mind when you lay your head down on your pillow. Because at that point, your business should not be in your mind. So even though the legal seems scary sometimes, and it seems like you don't want to talk to the lawyer, there's a lot of preventative work here in contracts and agreements. So relationships matter. In a lot of agricultural and farm work, there is a grassroots feel, especially in the sustainable organic world that I kind of niche myself in more than anything. And relationships matter. I don't think anybody would argue with me on that point at all. The community matters. People being able to live out their livelihood, get the things that they expect out of a business, it all matters. And every time we do business with somebody, we either build those relationships up or we break them down, either in a big way or in a slow, gradual way. So these are just some of my overall tips for those relationships, and they so clearly fall into the legal aspect as well. So it's not just the grassroots community feel of things. when it comes to doing business and owning a business, those relationships matter, especially the ones that affect your bottom line. And these are the things that you can do to make sure that they're as strong as they can be, that they're not slowly chipping away and eroding. The first is just to communicate clearly and directly. It's simple, but it's easy when you're busy, when you're an entrepreneur, when you're in business for yourself, to get caught up in the 1,043 things going on. But it's so important to take time and communicate clearly and directly with the people that you do business with, and outline expectations. And here's another piece where it takes time to know the expectations that you have for those people. And consider what matters to you as an individual, to the person you're doing business with as an individual, and then as a business and as the relationship. So I do this sometimes. I don't put hypotheticals in my notes, and then I go to make them, and it goes to a weird place really fast. So I'm trying to stop myself from doing that. But think about what matters to you. What matters most? Do you need the security? Excuse me. Thank you, Bourbon. Thank you. I have a dog who's been cooped up in the rain all day. My apologies. So consider what matters to you as an individual. What do you care about most? Is it the security of land? Is it selling X amount of produce this month? Is it, finding 4 more people that you can count on at the market? What matters to you most? What matters to the other people that you're doing business with? And then in the relationship itself, what matters most to the two of you? And that being businesses and individuals. And then contracts and written agreements help document all of this. And Chris and I were talking when he first entered in the room just about agreements generally, and agreements with, hey, welcome, and agreements with the city of Atlanta. And I've read a lot of those agreements, and they are very pro city of Atlanta. So I can see where it's very easy for someone. And I mean, even if I go back before I became an attorney, when someone handed me an agreement, it felt like it could have been a divide between the two of us rather than this holistic coming together. And it kind of is if it's one-sided and if it's not thought out. But when contracts are thought out and agreements are thought out, they help to bolster these relationships. And just a little set of pointers in negotiation too. And I was thinking about all the extra material that goes into contracts, and I was thinking about how long this presentation was getting as I was putting it together. And I realized that at the end of the day, it's just so important to remember not to be afraid of a written agreement, not to be afraid of that relationship aspect of doing business with somebody. You have a lot to offer when you enter into an arrangement with somebody, and make sure that that shows up. So read every agreement offered to you. That might make you cringe, but even if you're having a lawyer read over it, it is so important that you read those words too, and you start to get an understanding of what they mean. And when you read through your first commercial contract and you read through your first lease agreement from an established business, and it's pretty intense and there's lots of legalese in there, it can be very uncomfortable. But I assure you, the more you start reading them in your business, the more it's going to start start feeling fluid, and it will make sense more quickly and more effectively, and you will feel empowered from that. So read every agreement offered to you. And even if you meet with me one-on-one or another attorney, it's so important that we're on the same page, that you at least had that introduction to that material, and we have a place to bounce off of, to have conversation about what your concerns are in the agreement and what do you want to make sure is represented. Because if I read a contract for you and avoid without having, that context, it's not as helpful. Know what you need and what you want. So before you enter into a contract with another party, take some time to think about what's most important to you? Are with a lease agreement, we'll go into those in depth, but like, are you most concerned about knowing that you're going to have access to that land for the next 2 years? And like, that is the most important thing. Are you okay if the relationship doesn't last long? Is it a small parcel that's a part of 3 or 4 different parcels, and that's not as important that you be there for 2 years, but you do want to make sure that you have notice if they break the contract? Like, think through what you need and what you want. And the way you, well, we'll get into an agreement and I'll go into details for sure. And then be confident. Be confident. You know your business better than anybody knows your business. You know your bottom line better than anybody knows your bottom line. And you know what you need and what you want. So be confident in communicating that to folks when you're negotiating. And use track changes in Word. And I will show that specifically when I go over a lease agreement. I will show you what button to push in the most recent version of Word. And that keeps track of everything that you're concerned about in the contract for the other party to see. Very useful tool. And then any negotiation point you have a conversation with someone about, get it confirmed in writing. Either have them email you with it, or when you have a conversation with somebody that's not over email, if it's over the phone or in person, type up an email yourself with what you believe to have been the agreement and send it to them for confirmation. That writing is important, and we're about to get to why. But before we do, because there is so much information to go over when it comes to contracts and agreements, and even when I started looking at this material on a whole, my eyes started to burn a little bit. So before I just go down the contract and agreement rabbit hole, do any of y'all that are here have burning questions or concerns or specific things that are going on right now? Without giving me too much detail, don't go like into the nitty gritty and the specifics, but can you give me some context so that I can kind of tailor this conversation for you? All right.
Restrictions and limitations on what you can and can't do on a particular site.
Okay. Is that in a lease agreement?
Yes, something like that.
Okay. Awesome. Anybody else? All right, y'all feel free to jump in and stop me for sure, or throw a question in the chat as we go along. I'm going to speed through a little bit at the beginning here, but if something sends a light bulb off, definitely stop me and I will go in more depth. And Chris, I will get to those restrictions and limitations when we talk about lease agreements. I think that will be a really good place to fit that in. If you still have questions after we go over that, jump in, please. So the first big umbrella in contracts is when an agreement is binding. When are you stuck to terms in the agreement, or the other party? When are you both bound by that contract? And there are different phases of an agreement. There's kind of like a life of it. You know, there's conception, and then it actually becomes an agreement. And some agreements have to be in writing, but others don't. Some of them can be just handshake agreements with the people that you're doing business with. So for the phases of an agreement, to start with, and this is contract law 101. So there is a ton of nuance here. This is what lawyers argue over in civil lawsuits and in contract breach cases. This is where all the fun, if I may, happens. Oh, that was a very lawyer thing to say. My apologies. But this is where gray area can come in. But at the very, very basic level, for a contract to be binding, there has to be an offer, a clear offer, and everybody needs to be on the same page about what that offer is talking about. Acceptance of that offer And then consideration. And not just the being mindful and taking care in the relationship part. This is an actual legal term of art, which means that both parties are putting in something of value into that agreement. So paying rent to lease a piece of property, or paying a certain amount of money to rent a piece of equipment, that somebody is giving up their use of the equipment or their use of their land to someone, and someone else is paying for it. Payment is one of the most common forms of consideration, but there are others. In a bargaining agreement, you can have consideration from trading a certain amount of work for a certain amount of compost from somebody else's farm. There's consideration in both of those. Having it in writing and stating that that is the consideration is helpful, but just remember that there needs to be this offer, this acceptance, and consideration. If I promise to give you my 5-acre parcel of land in Atlanta when I move down to South Georgia, this is all hypothetical, but if I just promise to give you my land when I move down to South Georgia, that's not binding. If I'm not asking you to do anything in return for it, I can't be held accountable to actually stick to that promise. There needs to be consideration on both sides. And I see the question in the chat about internship or labor agreements. And Keisha will talk about those more in the employment and volunteer. I think that's November webinar. Great question. If you have something more specific, you can certainly ask me while you're here tonight. We'll wait to the end in the Q&A. And if you have something a little bit more focused for right now, we may be able to cover that in the Q&A. But internship and labor agreements will be in that employment and volunteer webinar. Okay, so phases of an agreement. And to break that down into even more practical terms, you usually start an agreement. You start an agreement with just conversation likely. So I didn't even put that as a bullet, but you have a conversation, you have an idea of how you can do business with someone that benefits both of you or that benefits one of you. You may email about it. You may shoot a few texts to one another about it. And then in the middle there, term sheets and MOUs are where we're starting to give life to this agreement, but it's not quite binding. And a term sheet is literally a bullet point sheet of the terms in an agreement. So, and I'm going to talk about specific terms like what rent is going to be, what access you'll have to a piece of property, what requirements you'll have. A term sheet just starts outlining those things for negotiation purposes so that parties have something to pass back and forth between the two of them. So everyone is on the same page and you can watch the negotiations kind of pan out on paper. Not a binding agreement. Kind of depends. Lawyers will argue that with certain things, but not a binding agreement. An MOU, which is a popular tool among nonprofits and in the food system community, especially the more grassroots food system community. An MOU, which is a memorandum of understanding, not a binding agreement. It's a tool that's used when two parties are working toward a common goal and they plan to work together on that common goal. So a memorandum of understanding is supposed to capture if you and I decide that we are going to start our own market, and I am going to, make sure that there's an agreement for it, and I'm going to do certain, I'm going to make sure that each person has signed that agreement and that we have the right signage for premises liability, and you're going to rally the farmers, and you're going to get 10 people involved, and you're going to talk to your CSA members about it. And there's like both of these things that we're going to do in order to make this bigger vision happen. That's the purpose of an MOU, not binding. If an MOU goes outside of that scope and you notice that it's not just talking about what you and another party will do, but it's getting into nitty-gritty terms, and a bottom line is affected, so money is affected, that MOU should be translated into something more of a formal contract or agreement. Let me back up a second and just kind of give context to why an MOU is not binding. You cannot enforce someone to do something. You cannot force someone. You cannot enforce an agreement for someone to do something. It's very tricky. It gets into weird, unethical places. So a judge can't, if we took an MOU to court, it just wouldn't make sense for a judge to say, you know, Michelle, you said you were going to do this agreement, so you have to. Very awkward, very weird. So there would have to be financial damages of some sort. There would have to be a monetary thing rather than that act of doing something. But an agreement, when you have that offer, that acceptance, that consideration, and you have written terms or unwritten terms, but just something that you agreed upon, that is binding. And this is where we get into some dense statute stuff, and I'm going to try and keep it as light as possible, but these are the agreements that must be in writing. And generally when it comes to products, so you may say to someone at the beginning of spring, yeah, I'll sell you 10 pounds of tomatoes for $500. I don't know if that math worked out at all. No, it'd be more like $50, $60. Sorry. But maybe 500. I wish that for you. That is my wish for you, that you sell 10 pounds of tomatoes for $500, $600, please. But when you just say that you're going to do that, and they're like, yeah, I will buy those tomatoes for $500, $600. There may not need to be anything else more than that. Those are the terms of the agreement. No worries. But in the farming context, there are specific agreements required to be in writing. And this OCGA is referring to the official code of Georgia. That's the state of Georgia's statutes. And that squiggly S is the section. So OCGA section 13-5-30 is our statute of fraud statute, and that outlines what agreements are required to be in writing. I only pulled 3 of those specific agreements that are relevant to farming in particular, but there's a whole list of them. They also involve marriage and estates and all of that. But when it comes to being in the farming world, any contract involving an interest in land that includes leases must be in writing. And any contract with a commitment longer than 1 year must be in writing. And any contract for lending money, a contract of an organization saying, we will give you this amount of money, but we expect you to pay us back with 20% interest or whatever. That's really high interest. But that would need to be in writing as well to be enforced. But of course, the next statute in the code has exceptions to that. And the provisions of the statute of fraud section do not extend if a contract has been fully executed, if there's been performance on one side, and where there has been performance, that trying to say that it had to be in writing makes it a fraud for the other party. Those are just exceptions to that writing. So I sum all of this up by saying, put it in writing. Just put it in writing. If you have an agreement with somebody, get it in an email, get it in a text, and those things count most of the time. An email definitely counts as a writing. A text, pretty sure that would count as a writing in most courts, most places, and in most arbitrations. So just put it in writing, get it in writing, send that confirmation email. All right, and then terms to include. And I want to back up to that be confident statement I was talking about in negotiations. When it comes to terms, you can include all the legalese you want to in a contract, but it's not always necessary. When you're working with another business or another individual on getting an agreement drafted, plain English is absolutely acceptable. So if you want to enter into a relationship with someone and you include these bullet points clearly And in plain English, you're off to a fantastic start. You can be confident, you can rest assured that you have captured an agreement that you can lean on. And those terms are who are the parties? Who are you contracting with? And that's where I put the who in quotes earlier. It's important to remember, is it you that's contracting as an individual, or is it your business that's contracting? That matters. And it's especially hard sometimes to separate the two when you are the business, when you're a sole member managing an LLC. Keep in mind, you're still two different entities. So who are the parties? What is the term of the agreement? When does it begin and when does it end? What are the expectations? And this goes back to taking a second to just know what you want, know what you need, and put it in English. And what happens if things go awry? There is so much room to CYA, to cover your assets, in that what happens if things go awry piece. This also ties back to that question of, are you thinking about any of your business relationships when you're winding down at night, and are you worried about them? That worry and that concern can be translated into terms in a contract that can cover your assets. If you are worried about being kicked off your property, because if you get kicked off your property in mid-July, you're going to lose $20,000, $10,000 in profits, put something in your lease agreement about not terminating an agreement during those dates. And if they are terminated, X amount, that 10,000 will be expected in damages, or that 20,000 will be expected in damages. Require it. And if it's less of a concern in December, if you're thinking, yeah, I'm entering into this contract in April to lease this land, I'm not sure if I'm going to stay here so long. It's running until April, but like if December comes around, December comes around and this isn't working out, I'm okay with being out. Then put those strict terms from April until August, and then say that to terminate it from August and December, both parties just need to give 30 days notice. And I'm spouting off hypotheticals, and I hope I'm not going down any rabbit holes too far, but I really just want to stress the point that if you have concerns about an agreement, you can add something in the contract to make sure that your concerns are dealt with or handled or addressed, or at least just put out in the open so that you don't have to hold on to it and worry about them. And then also under the what happens if things go awry umbrella is, if you're not a fan of the court system generally, and you're terrified of being sued, or you're worried that if you are sued, a judge and a jury wouldn't understand your business, they wouldn't quite understand the customs, nip that in the bud. Put something in your contract about what will happen in the case of disputes. This is what I would call an alternative dispute resolution clause. And that again can be in such plain English. So I should have made a slide about the alternative dispute resolutions, but I'll go ahead, I'll say them. They're not in writing, I apologize. But there's like layers. And the first layer would be mediation. Mediation can be as simple as each party choosing a mediator and those two mediators choosing a third to decide how things are going to play out after there's a dispute. So you can start with mediation and require that. Actually, back up. Before you even require mediation, you can put something in the contract that says, if there's a dispute, both parties should sit down and in good faith use every effort they can to come up with something between the two of them. Then mediation, which can be as loosey-goosey as you'd like it to be, which can be as written out, but you can define the terms of that. And then arbitration, which is usually governed by the rules of arbitration, but it's not the same as a court in the sense that you still have a little bit more of an opportunity to explain a novel business type, to really be heard and to try and come to a common consensus. And it will usually cost a lot less to do arbitration. And then if after all of those efforts an agreement cannot be reached to resolve the dispute, then a party can file a lawsuit. And you can even say if you file a lawsuit and you lose, you have to pay all the attorney's fees. So if you're concerned about what would happen if something went wrong and I were to get sued or there was a dispute, you can outline all of those things very clearly to make yourself rest easy. And then how do you get out of the agreement? That's the last like of the skeleton terms in an agreement. How do you get out? How does either party terminate it? What are the notice requirements? What the timing? What do you do to get out of that agreement? And I think if you can cover those bullet points in a written agreement, you're off to a very, very solid start. Everybody understands the expectations. And if they're in writing, you don't have to worry about human memories failing. So lease agreements are like one of the most important agreements, especially to urban and suburban farmers in the Atlanta area. I know a lot of farmers start out leasing land before they purchase their own. So this can make or break the growth of a farm business. And there's terms specific to leases, and I've bulleted some, but let me go ahead and pull up this lease. Oh no. Technical difficulties. All right, the lease won't pull up, so we will just go over the terms briefly here. And I do want to share a few words with you. I won't have them on the PowerPoint, but I will say them. If you want to jot them down, highly recommend doing that. When you have a lease agreement, in addition to those previous terms that I had, these are some important things to keep in mind. Describing the land to be leased in detail is incredibly important, especially if somebody is leasing a portion of their land to you. Knowing exactly what's being leased is vital. Oh, excuse me. And then when is rent due? How much is rent? When is it due? And how is it to be paid? Are important things. What happens if it's late? And even if you're the person who is leasing the property, it's so important to know these things. Again, so you can rest easy, you can have peace of mind, and you can know exactly what the consequences are if something comes up and you can't pay rent 1 month, or it's going to be a couple of days late. Who's responsible for maintaining the property around the farmland? So you may totally be ready to farm a certain portion of it, but do you also need to mow the area around it? Do you need to keep anything sightly for your landlord? And keeping in mind that a lot of landlords do not farm land themselves, are they going to be okay with an organic farm looking like an organic farm? Or do they want some sort of barriers up or some sort of specific maintenance? Talk about those things and know those things. Who pays the water bill in each case? Who pays the other utilities? What are you allowed to access and use as the person leasing the land, and what are you not? Somebody just put in the chat that they're hopping off in a bit. You can get the recording in the follow-up email that's coming in an hour. Wait, excuse me. You can get the previous recordings in. This one will be up within the next few days on that same page. So the link to where these recordings are will be going to you in an hour after this webinar. Okay, I'm going to stop my share and just go over some basic terms and read some words out loud that I think are important buzzwords to be familiar with in the farming lease world. And I will tell you, this lease that I found that to look over with you all was not written by myself. So it is full of incredibly dense legalese. I try to keep things a little bit conversational. I just think it's helpful for everybody involved to definitely be able to pick it up and read it. So this is full of dense legalese. If you are handed a contract that is like that, I thoroughly suggest trying to get through it. Pull up a web browser and be ready to Google a lot of words if need be. And there's plenty of resources for legal dictionaries and everything that you can access. And just try and read it, try and familiarize yourself with it, even if it feels way beyond the scope that you're used to. You will get used to these things more and more each time. And so the first part of a lease agreement is sometimes a preamble that has the witnesseth, whereas language before anything even gets to the terms of a contract. And a preamble like that with the whereas this and whereas that and whereas such and such, it's not required. But if you have an interesting or novel business relationship or structure, and for context, even having a social enterprise, even having a sustainable business that is focused on more than just a general bottom line, or if you're doing bartering of any sort, those sorts of novel relationships that may not make sense to a 60-year-old white judge outside of the Atlanta area, like that's sort of like the bar I would think of. Would the 60-year-old white male judge in rural Georgia understand what I'm doing? If not, go ahead and write a preamble up just to set the stage and give context to what you're doing and why you're doing it. That way your novel structure and the business relationship that you may have put a lot of thought and a lot of effort into coming up with the nuance for, it doesn't get lost in a courtroom if it ever gets there. The preamble is helpful just to illustrate the context. And then a definition section is really good. A definition section and having appendices of like an illustration of the actual property, like the property definition and the word definitions are very important. The way that you use words in your business and in farming may not apply to every business structure. So just making sure that everyone is on the same page with the definitions of certain words can go a long way. And then who owns improvements? This is really important to a farm lease. If you put a greenhouse up and it is a semi-permanent structure, are you allowed to take it with you when you go? Are you expected to take it down when you leave? Or when you put something like that up that's semi-permanent, does that become part of the landowner's property? However you want that to play out, you can negotiate for, but just keep that in mind. And then also soil. Amending soil is an incredibly valuable undertaking. It costs you time, it costs you money. So when you leave a property, you might as well put something in your lease about being able to take the soil with you when you go. A lot of landowners may not even be into farming. They may not be farmers themselves, and they may not be bothered by that at all. But if you don't think about it, there could be an argument of, no, you can't dig up my property when you leave. So nip that in the bud and just say you can take your soil with you when you go. And then the term of an agreement should definitely be in there. How long are you leasing this property? Who pays the insurance on a piece of property? The title insurance. You may have your own policies. Does your landowner require you to have certain policies? Knowing what's required and making sure you have it is important to not be in breach of your agreements. And then rent, how much is it? When do you pay? What happens if it's late? Who pays the taxes on the property? Decide that up front. And permitted and prohibited uses of the property. Go ahead and make sure in your lease agreement that anything that you've wanted to do on your farm on the leased land is a permitted use. Can you have farm dinners? Can you set up a market booth? Can you have volunteers on the property? Are you allowed to have visitors? All of those things, make sure they're on the permitted use if they're a part of your business model. And then prohibited uses, you as an organic farmer or sustainable farmer may want to have something in there about a prohibition against certain chemicals being used or certain herbicides or pesticides being used around the perimeter of a property. You can negotiate that with your landowner so you don't have to worry about that affecting your farming operations. Who's in charge of maintenance and repairs? And then the insurance that you're required to cover, that should all be in there. And any damage to property, especially if you are renting a tractor to get started and there's any sort of fencing, just think worst case scenarios, and then who's required to deal with those things. I think in the case of running over a fence with a tractor, though, the argument would be that it's your responsibility, but you can the contract that you create with the person you create it with, you can agree upon any terms. It is your own land of law. And then I think skipped just the meat and potatoes. Whether or not your landlord is allowed to transfer the land while you are leasing is something you may want to keep in mind. If you have a good relationship with your landlord, but you're not sure that a stranger would be someone you would want to work with, make sure that the contract addresses that. If you want to make sure that even if your landlord sells your land, that the lease runs with the sale of that land, that's also an option. Just negotiate it and put it in writing in that agreement. And then what happens if you don't pay rent? How long do you have to right that wrong? Will you have to pay any extra? Know those terms and negotiate them for yourself. Try everything you can to give yourself a big grace period. There's no harm in asking for sure and negotiating that. And then what constitutes notice among the parties? Are you okay between the two of you with a text being notice for something, notice of termination or notice of an issue that needs to be addressed? Is a text message enough? Should it be in an email addressed to, certain parties in specific, or should there be an actual USPS mailing? Think about what's important to you and your other contracting party, but just make sure it's clear so that you both have something to reference as your relationship grows and time passes. And then there's like lots of just legal terms that get thrown at the end of contracts. Don't be scared of them. Read them. Make sure they say what you want them to say. Governing law is one to look out for. Is the governing law Georgia? Is it specific to Atlanta? With a lot of contracts with the city of Atlanta, do they reference the code in any way? And are you good with that governing law? Modifications, if you do change the agreement that you're signing, how should you do that? Does that need to be in writing, signed by both parties? Indemnification, it's a mouthful of a word and it's a mouthful of a duty. I'm going to say it again. Indemnification. I'm even going to write that in the chat because this is a word I want you to look out for on any contract you sign. Indemnification is taking on the duty of representing and defending somebody with something. So a quick hypothetical would be, there may be something in a lease that if someone gets hurt on that property while you are in possession of the land, that you would indemnify the landowner. Because I tell you, if somebody gets hurt on your property while you are in possession of it, they are going to sue the landowner if they sue anyone. That's who has the actual property. That's cash money at the end of the day. So if they sue them and you have signed that you will indemnify them, then you have to pay an attorney to defend them in court when that person sues them. So just be very mindful of any indemnification clauses and make sure that it's not putting you in a position of taking on further liability than necessary. And try and negotiate that to, like there may be some instances where it's perfectly fair that you indemnify them, especially if you may have caused the harm in any way. It's just kind of moral and ethically right to then take care of it. But just know what the indemnification clauses are and make sure you're agreeing to it. That's a big one. And then with the governing law, underneath that is there's usually a jurisdiction and venue clause. And check that too, and see if it's convenient. If the land that you're leasing is owned by somebody who doesn't live in Atlanta, and they may have something about the jurisdiction and venue being somewhere far away from Atlanta, do you want to have to go far away if you have to deal with an arbitration issue? Is there a way of making it virtual? Now that a lot of the courts and a lot of the arbitration issues are dealt with virtually all the time, see if there's a way of mediating or arbitrating virtually before you have to go somewhere in particular to deal with a dispute. So that's, again, a lot of legalese. Read through your contracts. Be confident in yourself and knowing that you will know what it means when you sort through all of it. But when you ever reach a point where you don't know what it means, get a hold of an attorney. And right now, like at least through December, Foodwell Alliance is funding me to work one-on-one with farmers in the Atlanta area. So take advantage of that. And I'll tell you more about how you can do that. But if you read a contract between now and December and you're in the 5-county area, you have no excuse. Get in touch with me, get an office hour. Let's have a conversation about those terms and those agreements. And make sure that you are set up for success in your goals and exactly what you want. And then lastly, enforcing or ending an agreement. So if you are in a 2-year lease agreement, for instance, and after year 1, you have this phenomenal opportunity to move to a larger property, to own your own land, to, really level up your business, and it happened a lot sooner than you were expecting, you may want to end that agreement. And if something happens and you need to enforce it, both of those follow the same route. Check the written agreement. Go back to the writing. That's why it was memorialized in the first place, was so that time could pass and then you could go back and always reference exactly what's expected of you and what's expected of the other parties. So check the written agreement. What are the notice requirements in terms of time? Did you need to give a week notice? Did you need to give 30 days notice, 60 days, and follow that? Was that notice required to be via email, required to be via USPS? Know that requirement and follow it. Look for a termination clause specifically if you're ending an agreement. What does it take to terminate that agreement? Look for a dispute resolution clause if you're enforcing it. If someone has breached and you need to call them on that and hold them to it, find that dispute resolution clause and then start following the tracks of that. You may have a duty to try and work it out between the two of you as best you can before taking it to a lawyer to file a lawsuit. So save yourself the time of even getting to the lawyer and them telling you, well, first we have to do this. Just go ahead and look for that dispute resolution clause and follow that as clearly as you can. And if there is no written guidance, if you are amidst a handshake agreement and it starts to need to be enforced or ended, start a written trail at that point. That's when it's time to start putting what's going on in writing in an email. And even though you didn't start with a writing, go ahead and create that writing to just end things or to enforce things as cleanly and as clearly as possible. And the big takeaways are that business relationships can be strengthened with agreements. It's a lot of work. It's a lot of footwork to really sit down and think about who those relationships are, what matters most in them, how do we memorialize them, and then you go through all the tedious little clauses that you can have in a contract. It's a lot of footwork, but it really can strengthen the business relationships. And especially in a kind of a smaller, tight-knit community like the farming world in Metro Atlanta, the more folks rely on contracts and those written agreements that are really well thought out, the more harmonious it can all be at the end of the day, at least in my view of things. And it will help your bottom line to pay close attention to the agreements you enter into. It will help your bottom line. You can put a monetary value on things that might happen and make sure that you CYA, cover your assets, and be proactive in getting your needs met in agreements, especially when it comes to bargaining with a city or with a larger corporation. It can be intimidating. They hand you a contract, it has a lot of words, a lot of clauses, it could be 20, 30 pages long, and it feels very daunting and like you have to sign that. Like if you want to move forward in your business, that it may feel like that's your only option. But take a deep breath, be proactive, be confident, read through it and make sure that the agreement is everything you want and need it to be for that bottom line of your business. And then I cannot say it enough, read written agreements before you sign them. No matter how long, no matter how tedious, read them. And when I say this, I practice what I preach. I am that person in line to rent a car when I travel, reading the entire agreement that I'm signing for my rental car. I'm that person. I practice this, but I'm not asking you to do that. You don't need to take it that far. But what I do want you to take forward from this day on is read every agreement that affects your business's bottom line. There is enough risk to begin with in farming. Take some of it off with these agreements that you're signing. And then remember that legalese is not required in agreements. In very, very few contexts is legalese required. So if you just get something in writing in plain English, it is so much better than not having anything at all. And when legalese does come up and feel a little daunting and a little overwhelming, that's when it's time to consult an attorney. Just make sure you understand that language in some way, shape, or form before you sign to agree to something that affects your business, the health, and the relationships within your business. Okay, so I'm about to get to the office hours and how you can sign up for that. But before I do, are there any questions that have come up? I know there was a general question about internships and labor agreements. Oh, well, she's She's left already. So are there any questions? Thoughts?
When it comes down to maybe the agreements around the creation of products or something like that, do you have any guidance or ideas around those kinds of things, contracts or long-term usage, or maybe the product takes off or something like that?
Are you thinking like a value added product? Like if you grow strawberries and I'm making jam out of it? Or give me,
Yes,
okay.
something along those lines.
So I would again think through everything that gives you indigestion around that. Food pun not intended. But like what, think through and just journal casually, what are your concerns? If you're growing something and somebody's making a product, um, do they have an established business with that product already? Is there trademark involved? Are they going to be using your farm's name if they're making it? Think through all the things. Do you want certain ingredients to not be in that? Think through it very anecdotally and conversationally, and then put those terms in there, put those expectations in there. Does that answer that question, or was there something more specific you were thinking?
I think that's fine. Yeah, because like you were saying, really we can play with hypotheticals, but there are specific things that you would need to know in order to give like, a level of clarification that people will be looking for. Um, because say for instance, like, you created, I don't know, the jam,
Mhm.
and it took off, but there was nothing ever in writing to say about usage or anything like that. What does that look like? Because there's nothing that automatically says who owns what or who has rights to usage around recipes or branding and things like that. So those are just hypotheticals to kind of think through or kind of guide you with providing like a level of, I guess, specificity.
Absolutely. And, no matter how much thought any of us puts behind our agreements, there's always the chance that we will write up an agreement and it will seem like it includes every case scenario. But then something happens and someone ends up making hundreds of thousands of dollars and it becomes the biggest thing. And it's like, oh, dang, I didn't put anything about like royalties or any sort of anything to tie me to that. Like there will be those moments. Um, and this kind of takes my legal hat off and puts just like my intuitive human being hat on, and I think that's important for you all too, or any business owner, is to think through those things. Like, do you expect this to be a hit item? And and don't hesitate to include that in the contract. And that also brings up a point about getting templates off the internet. A lot of the times you get a template and it feels like it has everything you need in a contract, but like revisit all the moving parts of that. Like with the jam example, you brought up a great point with the thinking of the recipe and who owns that and who has rights to that. um when you have that thought, don't dismiss it, put that in writing. And if you struggle with teasing it out into how things would work, that's a great time to go ahead and call an attorney and start saying, well, what do I do with this? I'm about to, create something new with this person. How do we make sure it's split? And that also reminds me of the point that there are so many different types of agreements. So there are agreements to just sell a product and buy it. There are agreements that look more like partnerships, and they may fall into MOU land and they may not be super binding. And that's informative for your business choices, because if it's not very binding and you could end up, maybe gaining a little bit, but not gaining so much, you could end up putting a lot of heart and soul and time into it without seeing a lot of capital on your bottom line. It may not be worth it to even go there in that endeavor. Try
Okay,
to think.
thank you.
Yeah,
Um,
you're
let's
welcome.
let's see. Let's talk a little bit about maybe land safety when it comes down to leasing. So say for instance, you're a farmer, you lease some land from someone and turns out to have some kind of metal contamination or something, and
Mm.
that wasn't agreed upon or tested, at the time you agreed to the lease or made that purchase, and now, and your bottom line is definitely affected, something like that. How would that work? I think that may be a little bit better deep question.
Sure. And I think that's a very important one to think about in the city of Atlanta and in the urban areas where there is a possibility of contamination. I would say, ooh, that's such a good point. Chris, can I borrow you to get ready for every webinar to give me the good framework? So
Sure.
that's it's incredibly important to think about. I need this soil and I need it to not be contaminated. If you're already in an agreement and you find out it's contaminated, that's where you would maybe have to look towards that termination clause, but also get a negotiation with the landowner. If it's not in the clause or in the lease already, that's where you start that written trail. That falls into the camp of, let me see, the enforcing an agreement. You may not have something in writing yet, so start that writing trail. When something unexpected like that comes up, email the landowner immediately and say, look, there's contamination. Neither of us thought about this before. Here's, I wouldn't even say, how do you want to handle this? I would have a proposal already ready for them. I would like for you to handle this contamination um, before I continue paying you rent. But that it also brings up that in Atlanta, there should absolutely be something about testing soil first, and making sure that it's going to work for farming. And then if it's not working, you should be able to terminate that lease. And it could just be as simple as, once there's contamination, this lease is no longer in effect. Or once, if any contamination is found, this lease is no longer in effect. Um,
Okay.
Go ahead.
No, I was just acknowledging, what you just said. Let's see. Hmm. Come on, guys. I know it's other farmers on here. What other kinds of contracts and things do we enter into and kind of work on, or what are some of the things that we think through, maybe from a business perspective? I got one for you.
Mhm.
Let's say about maybe contracted deliveries or something like that. So, you have an organization that you work with that, delivers your produce or something like that. And, you know, because I guess for me, just thinking about this, it's not really a lot of, I guess, common sense stuff. It seems like everything has to be spelled out, in certain instances. So it's like, this happens, then this needs to happen. Nothing can kind of be handled on assumptions, I guess is a better way of saying that.
I apologize, Chris. Someone just knocked at the door unexpectedly and I zoned out. Can you repeat that question?
I was just saying something to the effect of, I just lost my train of thought.
Take your time.
I think you were saying something more so along the lines of, you can't always predict the problems with a lot of things. So having a contract in advance that covers things is not always even possible, because things kind of come up as they go along. You're like, oh, I see how this could have changed. And I think that's kind of where Chris was headed with that. I'm not sure though.
No, that thank you. That was about it. So something along those lines. So just like things you don't think about, or things that kind of would be assumed because you may be a farmer, and if this happens, then of course you should do this. But if that's not necessarily detailed and spelled out, you know what I mean?
with the, okay, this is great. There's lots of stuff in there to tease out. With the assumptions that you make as a farmer that not everybody may have, start writing those down like today. Start writing down assumptions that you've had experience, that you had them, but other folks don't. And then prepare to include those in, like in purchase agreements or in delivery agreements or in restaurant agreements. If you've already had like not issues, not capital I issues, but like lowercase I issues where everyone wasn't on the same page, create a Word document and just start keeping track of those things and staple it on as an appendix of all your agreements with those sorts of business relationships in the future. Of like assumptions that I make that you need to know. That is, it's not necessarily a legally binding portion of the contract. It can be, but it may not be, but it will just do so much good in everybody being on the same page. And that's, people don't sue people when everybody feels seen and heard. When everybody feels like they have the right information, people are a lot less likely to like escalate an issue immediately. So just having those assumptions as a running document, as a running list, as you gain experience, and just slap it on those sorts of contracts as a, here's what's happened before, and these are the assumptions or don't even say here's what happens before. Here's the assumptions I'm making that I want you to know about. That's one thing that you can do that's valuable and would be very cool. And I tell you what, if I went to do business with somebody and they already had that mindset, I would feel a lot more confident in that relationship to begin with. And then the second thing, for those things that are unexpected, is to use that dispute resolution clause as a place to decide how you will handle those with a person that you're in an agreement with. So even adding something into the contract that says this does not cover everything that can possibly happen in this risky and fast-paced relationship or industry. So when something comes up, here is the process of how we will deal with it. And it might be, just one, call the other party immediately to say if something has fallen off of schedule or if something is unexpected. Call the other party immediately and follow that up with an email. So there's a writing with timestamp. Like you can kind of put those things in place, knowing the business practicalities of what you're doing too. So it can already be written into when something unexpected comes up, this is what we're going to do. And then I also heard kind of a third question in there about things moving quickly and changing quickly. And that kind of goes to if you're making agreements on the fly. So if a restaurant comes to you and wants some produce that you have, like you just meet, pass somebody on the street. Okay, let me not get into the weeds of the hypothetical. If a chef comes to you unexpectedly, needs something, you have it, you don't have time to write up an agreement and you don't have a template ready, you certainly don't have time to meet with an attorney. All of that is way ridiculous for this scenario. So in that case, you go ahead, you do what you thought was the agreement, and then that's when you send that text or that email. When things happen on the fly like that, you follow up with wow, it was so great running into you. I'm so excited you need those 10 pounds of X produce, and I can't wait to see what you turn it into tonight. But I also want to remind you that, that you agreed to pay $6 for it, or however you would word that. I think I word that. I don't know if I would word it like that in the actual email, but just send that follow up after that to say, hey, this was what happened. I gave you this and you can pay me by such and such date, the agreed upon price of blank, and send that in an email or a text. So it's in writing for those things that happen on the fly. That was a lot of questions that came out of that. So I just gave a lot of answers at once. Did that all make sense?
I think it covered it, on my end. And I think, it'll be some opportunities when folks maybe view it, the recording, that they can definitely, you know, maybe follow up with some questions if you have time. So, you know,
Perfect segue.
there you go.
If you have more questions, sign up for office hours. Please, please, please. They are available to you. This is such an incredible resource that Foodwell Alliance is making possible. Thank you, Foodwell. If you're farm operations in Clayton, Cobb, DeKalb, Fulton, or Gwinnett, these office hours with me are completely free. Just go to calendly.com. That's the scheduling platform that I use, / the law farm / office hours. Sign up to sit down with me. We can talk about the agreements you do have in place. I'm not sure who's on that was on at the beginning and whatnot. I know the audience has changed a little bit, but I had talked about making a list of all the business relationships that you're in to start teasing out those agreements that matter the most to you and into your business. We can go over that together, think through little short form template agreements that you should have on hand. I can get those for you. We can do so much in an hour together. We can even do a follow-up appointment if necessary. It's an incredible resource. Use it, please. And then if you're outside these counties on this webinar, I'm offering these office hours to webinar participants for $75, and that's a huge discount. It costs $250 to sit down with me for an hour. Usually, these are incredible resources. Thank you, Foodwell. And you can always just reach out to me, Michelle at thelawfarm.com. If you're in that place where you haven't formed a solid question yet and you're still a little confused and unsure, reach out, and I would love to help get that solidified for you. So are there any other questions before we go? Anything holding you back from signing up for an office hour that you'd like me to address before you get off? Okay, that's all I have for you guys tonight. Chris, if you will hang back for 1 second.
Okay.
And
Did you want to?
Thank you.
Thank you so much. I'm so glad you were here.
Yes, all right. Have a good night.